Good evening, everyone, and welcome. I'd like to begin by acknowledging the traditional custodians from whose lands I'm speaking to you today, the Ngunnawal and Ngambri peoples, as well as the traditional custodians of the lands on which each of you are living, working and learning. I'm grateful to the First Nations people of Australia who've had an intimate relationship with this landscape and the sea country surrounding it for thousands of years. And as we talk about the modern law of the sea this evening, I'd like to pay my respects to the elders of this country, past and present, and to the culture, knowledge, kinship and connection that they hold, particularly in relation to oceans and the marine environment. Now, this webinar series is part of a continuing program that the ANU College of Law Centre for International and Public Law is running throughout 2022, in conjunction with the Australian and New Zealand Society of International Law. My name's Camille Goodman. I'm a senior lecturer at the Australian National Centre for Ocean Resources and Security at the University of Wollongong. But tonight, I'm here as the ANZSIL co-chair of this series, alongside the ANU co-chair, Professor Donald Rothwell. As you all know, 2022 is the year in which we will reach the 40th anniversary of the adoption of the 1982 United Nations Convention on the Law of the Sea. An exciting event will mark on the 10th of December. And CIPL and ANZSIL felt that this was a great opportunity to hold a series of webinars over the course of the year. And we've had two aims. First, we've looked to reflect back on the negotiation of UNCLOS and on its achievements through this webinar series held throughout the year, in which we're featuring senior scholars and practitioners from Australia and New Zealand and elsewhere, sharing their perspectives and insights on various aspects of the negotiation and implementation of the convention. And then as we move toward the end of the year, we're going to hold an event looking forward beyond 2022, where we'll look at the future of the law of the sea. We'll ask about whether the convention's still fit for purpose and what we might need to do to meet the challenges of the future. And that will feature work from the next generation of law of the sea scholars, our junior and early career scholars and practitioners. In our February webinar, we focused on Australian and New Zealand perspectives on the negotiation and implementation of the convention. And in April, we had a wonderful discussion about Pacific perspectives. And then in July, a fascinating keynote at the ANZSIL conference from Ambassador Tommy Coe, who gave us his regional and global perspective on the negotiations at UNCLOS III. So tonight in our fourth webinar, we turn to the institutions and implementing agreements of UNCLOS. And to take us into that discussion, I'm going to hand over to my colleague, Professor Donald Rothwell of the ANU College of Law. Over to you, Don.
Thank you, Camille, for that introduction, and good evening, good afternoon, everyone. It's a delight to be back with you in this webinar series again, as Camille has outlined. And as Camille has identified, we've tried to build through the webinars over the course of 2022 a number of perspectives on the negotiations at the 1982 UN Law of the Sea Convention, the third UN Conference on the Law of the Sea, and the way in which that convention has been implemented over the course of 40 years. So this evening we turn to institutional perspectives, and we have a very particular focus this evening on institutions that focus on the seabed, the Continental Shelf, and then from an organisational perspective, the United Nations. Of course, one of the other major institutions associated with the convention is the International Tribunal for the Law of the Sea and the dispute settlement mechanisms under Part 15 of the convention. And that will be the focus of our attention in our proposed October webinar. So stay tuned for some details there. We have 4 speakers with us this evening. 3 of them are physically present with us in the webinar. One speaker is currently in New York, attending the Intergovernmental Conference on the negotiations for an agreement on biodiversity beyond national jurisdiction, and that's Associate Professor Joanna Mossip. I'll introduce Joanna in a little bit more detail later, but because of the time differences, we elected to pre-record an interview with Joanna, and so we'll play that when we come to our segment. So our 3 speakers in turn turn are Dr. Phil Simmons, Mark Alcock, and Alice Ravel. And each one of those will address various dimensions of the institutional framework of the Convention. And the way that we're going to run this session is that I'll pose a few questions to each one of our participants and seek to engage them in some discussion on some of these key questions. We'll then hear from Joanna, and then we'll have opportunity for question and answers at the end of our session. So I'll go to our first panel member, and that's Dr. Phil Simmons. Phil is a former senior advisor in science and law of the sea in Geoscience Australia. And he was elected to the Commission on the Limits of the Continental Shelf, otherwise known as the CLCS, for 2 5-year terms from 2002 to 2012. And during that period of time, he was a member of 8 subcommissions. Phil is currently an honorary fellow at the Australian National Centre for Ocean Resources and Security, ANCORS, at the University of Wollongong, and he is a private consultant on the delineation of continental shelf areas beyond 200 nautical miles. And your special topic tonight, Phil, is the Commission on the Limits of the Continental Shelf. So welcome, Phil. It's great to have you join us.
Thanks very much, Don, for that introduction. Yes, it's no surprise, I guess, that I'll be talking about the continental shelf, the CLCS tonight.
So, Phil, let's start, I guess, with a bit of an historical perspective here. What are some of your reflections on the expectations set by the Convention on the CLCS and some of the issues that initially arose for the Commission in its early foundational years?
Yes, well, Don, it goes back a way, of course, and I'll try and do my best to reflect on the early history of some of the expectations with respect to the CLCS. But I should say firstly that my reflections come from the viewpoint of a scientist and not a diplomat or a lawyer, and that's really where the focus of the CLCS lies. And also, surprisingly enough, it only relates to 630 words of Article 76 and 840 words of Annex 2 of the Convention, which is, I think, about 2% of the words of the Convention. So it's a very small part of the Convention in terms of words, but it's, I think, a very important part in terms of marine jurisdiction. So, yeah, reflecting on the expectations of the set by the Convention on the CLCS concerning the delineation of the continental shelf beyond 200 nautical miles, which I'll probably refer to during this discussion as the extended continental shelf for the sake of simplicity, they really relate to the way Article 76 and Annex 2 of the Convention were written and negotiated in the very beginning. And probably one way of starting this discussion would be just to have a bit of reflect on a bit of background with regard to those parts of the Convention, because those parts of the Convention really raised the expectations of what the Commission is, what the CLCS is about, and what its work was going to consist of, and how it was going to relate to coastal states. And I should say that Article 76 of the Convention, of course, is related to is the part that requires states to make submissions for its continental shelf beyond 200 miles to the CLCS, and Article 76 and Annex 2 of the Convention both refer to this, and also they require states to submit particulars of limits of the continental shelf beyond 200 nautical miles, along with supporting scientific and technical data, and that submission has a 10-year time frame for making the submission from the time that the Convention entered into force for that particular state, which of course initially for most states was based on the adoption or the entry into force of the Convention in November 1994. Now, Annex 2 stipulates that the CLCS, which is a solely scientific body, has 21 members, and they're supposed to have expertise in geology, geophysics, and hydrography. They're elected for 5-year terms and based on an equitable geographic relationship from the various 5 UN groupings. They're eligible for re-election and their expenses are paid by the nominating state. So that sets the scene a little bit for the types of people that are on the CLCS. there's also a trust fund was established to support the participation of members from developing states. So that's allowed quite a few members of the Commission to participate in the workings of the Commission of the CLCS over many years. The CLCS considers the information submitted by states and makes recommendations to the state on matters regarding the establishment of the outer limit of the continental shelf, or the outer limit of the ECS. And of course, those recommendations are, if a state implements its or proclaims its continental shelf on the basis of those recommendations, they become final and binding. The CLCS is based in the UN headquarters in New York. Its secretariat is the division is based on inside the Division for Ocean Affairs and Law of the Sea, which is UNCLOS, of course. And this is very different to the other UNCLOS institutions, such as the International Tribunal on the Law of the Sea and the International Seabed Authority, who have their own independent secretariats. And that actually has quite an influence, I think, on the way the Commission or the CLCS has operated over the years. The various formulas, as most people will know, the various formulas and constraints contained within Article 76 of the Convention require information on the morphology of a state's continental margin, its shelf, slope and rise and the adjacent deep ocean floor, on the water depth across the continental margin, and the distribution of sediments across the continental margin, particularly on the continental slope. So there's a large amount of diverse marine data and information required on the seafloor and subsoil in water depths ranging from 200 to over 5,000 metres that a state has to consider in making its submission. Now, this background that I've just given you sets up a number of expectations on the Commission when the Convention entered force on 16th of November 1994. The first election of the members of the CLCS was held in March 1997, and its first meeting took place in June 1997. And the CLCS since that time has held 55 sessions. So it's been going for quite a while now, and it's got a number of sessions over the years up to the present day. Now, the expectations of the CLCS in its early stages included probably firstly, the need to develop procedures for its operation interactions with submitting states, including such matters as the format of submissions, the examination of submissions, the preparation and adoption of its recommendations and things of this matter. And the CLCS needed to clarify how it would handle submissions in the case of disputes between states and to deal with the safe custody and confidentiality of submissions. Now, all of these matters were contained within the rules of procedure that were initially adopted in September 1997 and have been revised and updated several times since, with the current version being adopted in April 2008. There was also a need, of course, for the CLCS to clarify its interpretation and understanding of the scientific and technical, the technical and legal terms really contained within Article 76 of the Convention. In particular, to clarify the scope and depth of the scientific and technical data that would be needed to be contained within submissions and that would subsequently be examined by the CLCS itself in making its recommendations. This was necessary probably mainly because some of the scientific terms used in Article 76 are used in a legal context, but they sometimes depart significantly from the accepted scientific definition, so there can be some confusion. So there was need for a clarification on these matters. There was also terms that were open to several possible and equally acceptable interpretations, and there needed to be clarification on matters such as that. So anyway, at the end of the day, most of these issues and matters were contained and discussed within the scientific and technical guidelines of the Commission, of the CLCS, which were researched, prepared and amended during the period 1997 to 1999. And the final and current version of these scientific and technical guidelines was adopted in May 1999. And the drafting of these guidelines was clearly a very important achievement of the Commission towards the implementation of Article 76 of the Convention. And these guidelines have served several purposes over the years. They were primarily intended to assist states in preparing their submissions, of course, but they're also designed to provide important scientific and technical reference for the consideration of submissions and for the preparation of the Commission's, the CLCS's own recommendations. They also could form the basis of any advice that the Commission or the CLCS was requested to give to coastal states. There was also, arising from the data I referred to earlier and the amount of data that is required to be in a submission, there was a need for the Commission of the CLCS to be able to store and manage and analyse large amounts of hard copy and digital information contained within a variety of forms and submissions, and for the CLCS to be able to examine and analyse this data in a timely manner. And such matters were dealt with or taken on board by the Secretariat of the Commission by ensuring the necessary space, computer hardware, software, and support staff were available within the DOALOS offices and at the UN headquarters for the Commission and sub-commissions to meet and consider submissions. And this led to the establishment ultimately of 3 GIS laboratories within the DOALOS offices, all fully equipped and staffed, which is quite an unusual undertaking at the time for the UN. There's also a need to publicise and notify states of submissions that were made to the CLCS, and this was done by the Secretariat through the Commission's website. And this website also formed an important source of information on the workings and activities of the CLCS and the implementation of Article 76. Excuse me. There was a need, obviously a need to adopt recommendations in a timely manner. This was not only an important consideration for the submitting states in terms of having confirmed delineation of their national UNCLOS marine jurisdictional zones, but is it also important for the international community? Because the outer limit of the continental shelf is really the inner limit of the international part of the seabed, the area. And that is which is the responsibility, as we all know, of the International Seabed Authority. Without knowing the full extent of the continental shelf and the limits of national seabed jurisdiction, the full extent of the area remains unknown. And this is becoming increasingly important as the exploitation of the area under the management of the ISA draws ever closer. This also remains a very important matter for states because long lead times for the receipt of recommendations can affect the currency of data and information and the analytical approaches contained in submissions, very important matter for states, and can extend the time that a state needs to keep its scientific and technical knowledge and expertise related to the application of Article 76 in place to be able to support and defend its submission during the interactions with the subcommission and the Commission. The timeframes for this can be difficult for any state to deal with, particularly small island and developing states, as you can imagine. The long submission queue facing the CLCS is an ongoing issue, and perhaps we can come back to this later in our discussion. And I just wanted to touch on it now because it was and is and remains a very important matter for the Commission and also for the states making submissions. Along with the early stage expectations and issues already discussed, there were other matters that arose during the early years of the CLCS. These include the need to clarify the participation of states in the proceedings of the Commission. There was initially some controversy about this, and this was ultimately clarified through amendments to the CLCS rules of procedure. There was a need to develop procedures to make Commission views and recommendations more visible to states, particularly those preparing submissions, and this was dealt with in part through the provision of the summary of the recommendations, which commenced in 2008. There was a need for consistency of the content and form of recommendations, and this was developed and refined throughout the period of 2007 to 2010, and quite a number of other issues, but I won't go into them all now because of the situation, because of our time constraints. Perhaps we can come back to some of these later. I think I should finish my initial comments here, but I just wanted to say that it's pretty clear that during the negotiation of UNCLOS, many state representatives would have had little idea of the real number of likely submissions that the Commission was going to have to deal with, the CLCS was going to have to deal with, as well as their complexity and the amount of detailed work and time that would be involved in the consideration and preparation of recommendations on submissions. Some might say that the Convention never envisaged the CLCS performing such detailed examination of submissions, but many others agree that such detailed consideration is necessary and expected from such a body. The CLCS has now been operating for about 25 years and has developed its approach to the consideration of submissions throughout this time. And I expect there is no going back now. So I might leave the response to that question now, and hopefully we can touch on some of these other matters in our ongoing discussion.
Phil, just a very quick follow-up. Can you just remind us all what was the initial expectation during the negotiation of the convention as to the number of submissions that the CLCS might be dealing with?
Well, there was a map and some documentation prepared by Lamont Doherty Institute very early on in the towards the middle, I think, of the negotiation process, and I think they defined about 60 to 70 areas that may have potential, where there may be a potential submission for extended continental shelf beyond 200 nautical miles. Of course, we now know that this has blown out considerably, and it was. Remember, at the time this was done in the 70s, the data sets available to make those assessments were quite limited, and in many cases, in some areas, still remain so. But that was probably the accepted view at the time.
Great. So, Phil, can we just move on to some of your observations as to the work of the Commission over the past 20 years? You've obviously made some preliminary points around that, and some of the major challenges that the Commission has faced. Okay,
well, of course, during my 2 terms as a member of the CLCS, as you mentioned in your introduction, I witnessed a very rapid increase in the workload of the Commission, and this really followed on from the new May 2009 deadline that arose from the decision of the meeting of states parties in 2001 to align the 10-year deadline of the Convention with the adoption of the scientific and technical guidelines of the Commission, which occurred in, as I said, in 2009, in May 2009. After leading up to 2009, there was an explosion in the number of submissions that were really that occurred, and the work and the queue, the extent of the queue of submissions, has remained very significant from that time on, and I will probably come back to that in a little while. What I'd like to focus on just briefly is some of the achievements, rather than focusing on just the issues and potential problems associated with the Commission's work. I'd like to focus on, firstly, some of the achievements of the Commission. And it's important to recognise that up until August 2022, in fact, just the other day, a few weeks ago, there were 92 full or partial submissions and 9 revised submissions made to the CLCS. That's a total of 101 submissions. These involved 80 separate states. 55 of these were partial submissions, and 7 were joint submissions involving more than one state. So you can see the complexity and variety of submissions that the CLCS was dealing with. 16 of these submissions were made up to the end of 2008. 35 during 2009, and 42 submissions and 9 revised submissions, totaling 51 submissions, have been made in the 12 years since that time. So you can see the explosion in submissions that arose during 2009 as a result of the changed deadline, and the focus that states suddenly took on the deadline really looming up in front of them. And many of them, of course, we're going to miss the original 2004 deadline. And that was one of the reasons that this deadline was altered, and it seemed a reasonable thing to do. And of course, things have changed a little bit again since then. But it's also important to recognise that the number of submissions have been deferred by the CLCS due to them being subject of disputes related to Annex 1 of the Rules of Procedure. And these remain in the queue until such time as the disputes are resolved. So there's other submissions sitting there that can't be looked at the moment by the CLCS. There seems to be the potential, you mentioned before in your question about the number of submissions that were perhaps expected during the negotiation of the convention. There now seems to be the potential for over 120 plus submissions. And this doesn't take into account potential revised or new submissions. And of course, we've seen already that there's a number of revisions to submissions being made by states as a result of the recommendations of the Commission. And these, of course, go to the top of the queue, following on in the order in which the revisions are made. So this does, countries that may be expecting to have their submission looked at a certain time suddenly become delayed because a number of revised submissions appear in the queue. So all these things add to the complexity of dealing with the submissions at hand. Excuse me. To date, the CLCS has adopted 35 recommendations, 18 in the 10 and a half years leading up to the new working arrangements it adopted in 2012, and 17 in the 10 and a half years since those new arrangements were in place. So not much has changed as a result of the new arrangements in terms of adopting recommendations, although we have to be fair to the the more recent commissions, in that the later period up to 2022 obviously included that COVID period of 21-22, where of course the work of the Commission was somewhat constrained. In fact, there were many sessions, or a number of sessions, delayed and put off, postponed during that period. The recommendations that the CLCS have made to date relate to about 31 separate coastal states. And the Commission, it's interesting to note that the Commission's recommendation to date confirmed national jurisdiction over roughly 10 million, this is rough because it's a difficult figure to work out, but roughly 10 million square kilometres of seafloor beyond 200 nautical miles, approximately 29% of the area covered by submissions to date. So it's a fair, substantial area of seafloor involved in the recommendations to date. Approximately 29% of the area, yeah, that's right. About 26% of the likely total area of extended continental shelf, the total amount that may ultimately be submitted. This has all happened in a peaceful and ordered way, consistent with the ideals embodied in the Convention, and has opened up expanded resource and environmental opportunities for the states involved. And I think it provides very good evidence for the number of submissions and the number of recommendations adopted, that this part of the Convention is working and doing the job that it was originally expected to do. And of course, it shows that the process has been strongly supported and embraced by states parties, and it's working effectively to promote the peaceful use of the ocean. So returning now to the other part of your question related to the major challenges over the last 20 years, many of these still remain significant to the CLCS. And of course, the big one that we've already referred to is the workload and timely consideration of the large number of remaining submissions. And this is clearly the number one issue. And there is a risk to the CLCS that, working under its current modifier arrangements, it will still not be able to deliver recommendations until sometime after, all submissions potentially that could be made, until sometime after 2040, a long time down the track. It's unlikely that this is going to be acceptable to the states concerned and to the international community. And there's no doubt that new approaches are needed and will have to be considered at some stage. Now, a new approach was adopted at the request of states parties in 2011. Up until that time, the Commission had been conducting its work usually at 2 sessions a year, and perhaps up to a variable number of weeks per year, because sometimes subcommissions were meeting independently of Commission sessions. So it's a bit confusing in that early time. But I remember from my own experience that I would never be in New York for more than about 16 weeks at a time. Now, under the new arrangements, the Commission members are expected to be in New York for up to 21 weeks a year, and potentially up to 26 weeks under these new arrangements. I think it's mainly stayed at about 21 weeks. This is done usually these days through 3 sessions throughout the year, and 2 of those sessions usually have 2 plenary, 1-week plenary sessions attached to them. The other one at the end of the year, very end of the year, is usually just a solely a subcommission working session. Unfortunately, this new approach that has been adopted in 2012 with the Commission that commenced its work at that time, and that was the time that I've never experienced this new working arrangement, because that was the time that I departed from the Commission. This new approach hasn't really led to significant improvement in the rate at which recommendations were adopted. In fact, the rate went from about 1.7 recommendations per year under the earlier arrangements up to about 1.9 per year post 2012. So it hasn't made a massive difference. And there are a number of reasons for this, and some of them are inherent reasons for the way the Commission works and the way that it interacts with submitting states. So I won't go into the details of all these now, but they do relate to particularly the interactions between subcommissions and delegations. It's hard to judge how long they're going to take and the way the discussions will go, and this can cause delays and confusion about the amount of time it's going to take to finish consideration of a submission and adopt recommendations. So I think I'll leave that there, unless you've got any follow-up questions to that.
Thanks so much, Phil. I think we might just take the opportunity to move on to our next speaker. There's actually a question that you've received in the chat that you can contemplate. So our second member of the panel is Mark Alcock. Mark is at Geoscience Australia and has been the Director of Georegulation there since 2008, where he has responsibility for leading the Australian scientific and technical program that manages Australia's offshore boundaries. Most importantly for our discussion this evening, Mark was elected to the Legal and Technical Commission of the International Seabed Authority in 2017, and he's been re-nominated for a second term commencing in 2023. So Mark's discussion of the International Seabed Authority flows on very nicely from Phil's discussion of the CLCS, given the interactions, at least legally, from a structural perspective between the two. So Mark, welcome. And can we just get you to commence with some of your observations as to the role that was initially envisaged for the International Seabed Authority when the Law of the Sea Convention was concluded, and of course, importantly, under the 1994 implementing agreement?
Thank you, Don, and thanks for that introduction. And I'll just have a quick diversion to say that I thank Phil for his mentorship over the years. Otherwise, I would not be in a position to undertake this work at the LTC. But really, I think it's very interesting to see the changes between the original conception of the International Seabed Authority and that existed after the 94 agreement, because it was, the original conception was to have a much more economically active body. There was the expectation that there would be an economic planning commission that would be setting quotas for production, that would be looking closely at the management of prices for the commodities that were being mined. And also it was expected that the International Seabed Authority would be commercially active and developing the resource itself, either independently or with participation by states or other entities. And it was very much it very much reflected a view of the world that probably existed during sort of the 1960s negotiations or the discussions on the peaceful uses of the seabed. But the world changed a great deal really during the 1960s and 1970s, where the idea of centralized management of resource production really disappeared, particularly in the West. And I'd remind people that up until 1960, it was illegal to export iron ore from Australia. And those controls were not lifted until 1966. And we did not have world parity pricing on petrol until 1976. So quite close to the end of the negotiations. And even in countries like the UK, it was not until the government of Margaret Thatcher that the economic rationalist approaches that these kinds of controls left the ideas of Western states. But really the 1994 agreement really reflects more modern, I suppose, Western ideas, at least, that the industry should be able, the prices would be set by the market, and production quotas would not be applied. And although there is still the possibility of the enterprise undertaking commercial activities, the rationale for an enterprise really is much less strong under the current arrangements. So it really, a large part of the work that was considered to be necessary for the International Seabed Authority was really removed because of it, so that it has become much closer to a modern resource regulator, I suppose, certainly in the Western context, which has raised tensions, although the agreement resolved tensions at the time that allowed the convention really to be ratified by more states. It has raised some tensions within the International Seabed Authority because those commercial constraints or constraints on production were important to developing states, particularly in Africa and South America, and that does give rise to some of the tensions that exist now.
Thanks, Mark. That's really valuable in terms of having that context and understanding how there's been an evolution in terms of the thinking about the ISA, but also the economic, political and geopolitical and resource circumstances that you've mentioned. So given those observations, and now especially your recent role on the Legal and Technical Commission since 2017. Can you make some observations on the performance of the Legal and Technical Commission, especially some of the challenges it has been facing?
Thanks, and I think this is, well, I mean, the question raises some interesting challenges for a body like the Legal Technical Commission, which is often, whose role is perhaps less well understood by people who don't see how it fitted in within the negotiations of the convention. To me, and of course, as a member of the LTC, we're unlikely to say that its performance was deficient. But to be honest, I think it's amazing the amount of work that the LTC has been able to achieve in the last 5 years, where the pressure on the LTC to finalise regulations for the consideration of the Council and the development of the standards and guidelines has been an enormous task for a part-time body trying to do the work that would in Australia be undertaken in the resources portfolio by NOPTA, National Shore Petroleum Titles Authority, National Shore Petroleum Safety and Environment, and parts of Department of Environment and even parts of the Australian Maritime Safety Authority, essentially working in the evenings and the weekends and in between. But the diversity of work is, I think, above all else, the greatest challenge, where the members of the Commission, who are quite well supported by the Secretariat and have incredible access to people around the world to provide advice on all of the matters that are relevant for its consideration. But being able to keep all of that information within your head in a way to be able to integrate it with the expectations under the convention. And of course, it does link in the regulation of the seabed is also tied into domestic regulation and the positions of states and what they are prepared to have imposed upon them. I think it's really above all else the complexity that is the greatest challenge. But in terms of the perception of the Commission, I think its greatest challenge has been the unwillingness to have any elements of the meetings in public. And so that has given rise to a perception that the Commission is not taking on board the positions of civil society or of states. That it has provided a rod for its own back in terms of its perception of effectiveness. But what I would say is all the way through the COVID period, we did maintain our meeting schedule. Of course, not having 2 weeks in Jamaica every 6 months, we were meeting for essentially a month, several hours a night. And so that did add additional challenges, particularly with the addition of the 2-year deadline that was imposed last year. So it has been a very heavy workload. And I suppose from a personal point of view, I think as a new member of the Commission in 2017, it took me about 2 years to work out what on earth was happening and how the process worked. And that was one of the other challenges. It is a very steep learning curve.
Can I just ask for a clarification? Phil gave us a bit of a sense in terms of the workload and the number of weeks that members of the CLCS had to spend in New York. Can I just confirm from what you have said that the annual expectation would be approximately 4 weeks in Jamaica for members of the Commission for the work that you've been undertaking?
That is correct. Although certainly during the COVID period, we had a large number of there's a large amount of intersessional work and subcommittee work, but only 4 weeks face to face.
Thank you. So, Mark, with all of that context that you've given us and your observations, and the fact that the International Seabed Authority is quickly coming under a lot of focus and attention from all sorts of quarters, how do you see the role of the Seabed Authority moving forward into this critical period when deep seabed mining is on the brink of commencing?
Well, I think there is the, well, perhaps it's worth saying or just pointing out just how close the possibility of mining is. And so this year, well, in the last year, there has been testing of the components required for mining. And one of the companies, Nori, was expecting to be undertaking what is effectively test mining as we are speaking this month. Now that has been delayed until September because of some equipment failure. But essentially, the equipment to undertake mining is in its final testing phases with 50% scale equipment, with the companies aiming for production perhaps as early as 2024 or 2025, probably more likely 2025. And for those companies, there is a strong commercial imperative to start production that early. So really the main, well, obviously the main role of the ISA is going to be acting as a conventional resource regulator and managing the industry, but given the rapidness of the onset of mining, it is highly unlikely that the regulations, and certainly with so little experience in the activity, that the regulations will be perfect, even if they are complete. And so in the early stages of mining, there will be the application of the regulations in whatever state they exist in the middle of next year, or when mining or the first contracts are issued. But there'll be a very steep learning curve, and one would hope that there would be room within the regulatory system for it to respond to the early lessons of production, so that the regulations do not stand at where they are at the very beginning, but like other industries, as you learn, you improve. And that'll be my main comments there. Thank you.
Thanks so much, Mark. So I'm going to move on to our third panel member now. Alice Revell is joining us this evening from Wellington, where Alice currently manages the international relations team at the New Zealand Ministry for Primary Industries. But the principal reason why Alice has been invited to join us this evening is that Alice previously was at the New Zealand Ministry of Foreign Affairs and Trade, where she worked for many years in international law and foreign policy roles. And these included managing law of the sea and international environmental legal issues, including the New Zealand team to UN negotiations for the current negotiations that are taking place that I referred to in New York on biodiversity beyond national jurisdiction. And Alice was also posted in New York for 3 years at the New Zealand Permanent Mission to the United Nations. So Alice is very well placed to give us some perspectives on the role of the United Nations and the General Assembly, especially in terms of the Law of the Sea Convention and some of these institutional mechanisms that we're looking at this evening. So welcome, Alice. It's great to have you join us this evening. To begin with, can you remind us as to what your understanding was of the ongoing role of the United Nations General Assembly at the time that the Law of the Sea Convention was concluded back in 1982?
Thank you, Donald, and thanks to you and Camille for inviting me to join this very prestigious panel. Just before I start, I should just say that although I have worked in many different roles for the New Zealand government, the things I'm going to say this evening are just my own views. So it's a great question, actually, about what do people think the ongoing role of the UN General Assembly would be at the time that the convention was concluded. And I had to actually go back and have a bit of a look because I was very young at the time that the convention was concluded and I wasn't doing this kind of stuff back then. So I had to actually go back and have a look, and I had a feeling, and it turned out to be right, that there was probably quite a kind of limited administrative role envisaged for the UN General Assembly. So there's a UN General Assembly resolution 3766, which was adopted on the 3rd of December 1982, just before the convention itself, preparing for that final act adoption and the signing and opening of the convention for signature the following week, just in time. That resolution approved the UN Secretary General assuming the responsibilities assigned to him under that convention, and it included financing the expenses of the preparatory commissions for the International Seabed Authority and the International Tribunal on the Law of the Sea, and it requested the UN Secretary General to report the following year on the implementation of that resolution. So it was pretty limited, really, in terms of what it envisaged the ongoing role of the UN General Assembly would be. And it's only really later, when the convention was much closer to entering into force, that the UN General Assembly seems to have really taken on a much broader role for itself in the 1990s. And I think, for example, if you look at the meeting of states parties, that is referred to in the convention in Article 319, paragraph 2E, and it says that the Secretary General shall convene necessary meetings of states parties in accordance with this convention, and then obviously, you know, in conjunction with that resolution I just mentioned. So it's all kind of there, but I don't think that anyone really envisaged that there were going to be several implementing agreements following the convention, and that they would be negotiated through the General Assembly, and also, of course, all of the annual resolutions and all of the other bodies that have since sprung up from it.
And I guess, Alice, as a comment on that, that's not necessarily exceptional, is it, to the Law of the Sea Convention? It's quite common in terms of a number of the major multilateral conventions that these frameworks just spring up over their lifetime.
That's true, and the challenge for the Law of the Sea Convention is it doesn't have an equivalent of a conference of parties like a lot of more modern conventions do, which sort of allow for that process a bit more organically.
So that sort of leads us on to our next question, in terms of reflecting a bit on your experience when you were with the New Zealand mission in New York and able to observe and participate in some of these UN processes that you've alluded to. What are your reflections on the role played by the so-called state parties to the Law of the Sea, otherwise known by the acronym SPLOS, and the United Nations open-ended informal consultative process on oceans and Law of the Sea during that time?
Well, I was in New York quite a while ago now. It was 2010 to 2012. So I attended 3 meetings of SPLOS during that time, states parties to the Law of the Sea, and also 3 meetings of the UN Informal Consultative Process on Oceans and Law of the Sea, which is sometimes called ICP and sometimes UNCLOS, which I think sounds a bit more exciting. And at the time, I had to look back and remind myself what was SPLOS dealing with at the time. And it was dealing with some of the perennial issues of electing members of the International Tribunal for the Law of the Sea and the CLCS. It was dealing with the budget for the International Tribunal for the Law of the Sea, the remuneration of its judges and their pensions. But it was also dealing with some other issues like the workload of the Commission on the limits of the Continental Shelf. And I think Phil has given a really fantastic overview earlier of just some of the changes that have happened for that Commission over its lifetime. And I think really the fact that there wasn't sort of remuneration provided for and all of the other things, because nobody really anticipated the extent to which that commission was going to become the phenomenon that it has become, with great big waiting lists and so many states making submissions. So there was a lot of work being done on that at the time as well. The UNCLOS, UN Informal Consultative Process on Oceans and Law of the Sea, at the time it had thematic meetings each year looking into sort of contemporary issues in oceans and law of the sea. In 2010, it was looking at capacity building in ocean affairs and law of the sea and marine science. In 2011, it was looking at the contributions that the Law of the Sea had made to the UN Conference on Sustainable Development, and remembering that now, that was really in preparation for the Rio+20 conference in 2012. And in 2012, the theme was marine renewable energy. So you can sort of see how the UNCLOS was kind of playing a role in a very informal way, because it at that point had no longer had any kind of effort to try and reach negotiated outcomes. That had been tried a bit earlier, but it was basically abandoned because it was too difficult. So it was kind of an information sharing and idea generating forum at that point that I guess enabled new issues to arise and have a forum, because that is one of the challenges for the Law of the Sea Convention, that while the convention itself remains the same over time, the contemporary issues that people are dealing with in relation to oceans have definitely changed. So it's kind of necessary to have some forum in which states can get together to discuss those things. And UNCLOS really was playing an important role in that regard a decade ago. And I should also mention there were a number of other Law of the Sea bodies at that time, some of which continue. There was the ad hoc working group on biodiversity beyond national jurisdiction, and I can talk a bit more about that maybe later, what that turned into. There was the regular process on world ocean assessment. And then, of course, there were the annual UN General Assembly resolutions on oceans and on sustainable fisheries, each of which needed sessions to negotiate those each year. And then, of course, also under the auspices of the convention, there were many UN fisheries meetings related to the UN Fish Stocks Agreement. So the informal consultations of states parties, the review conference of the Fish Stocks Agreement, and also the regular reviews of bottom fishing, which and including the first multi-stakeholder workshop on that, which was held in 2011, which I chaired. So there were a lot of things going on, even though there was sort of no formal decision-making body that could really take them any particular direction.
Those are really important insights, Alice, because I think what you're suggesting to us is that if you look at the convention itself, it doesn't really give us much clue as to all of these additional activities that are taking place within the UN framework. And I guess that brings us to what's happening this week and has been happening for the last few weeks in New York. And here I'm just asking you a question to get you to reflect a little bit about how those processes have evolved, and that will lead into Joanna Mossip's contribution. So we know that the General Assembly has been engaged in the critical processes associated with giving a mandate to the Intergovernmental Conference assessing biodiversity beyond national jurisdiction. What are your observations on those processes and the future role of the UNGA moving forward for the Law of the Sea Convention?
Well, I think, as I mentioned just before, this Intergovernmental Conference on Biodiversity Beyond National Jurisdiction, or BBNJ as it's often called for short, really it grew out firstly out of a UNCLOS meeting before my time in New York, which looked at some questions related to marine genetic resources. It also grew out of then an ad hoc working group that was established and ran from 2006 until 2015, which looked at these kind of somewhat unresolved issues in the law of the sea, I suppose. And some of the concerns that eventually came through in that process were concerns about whether or not marine genetic resources were analogous to mineral resources under the convention, and therefore whether they should be treated as the common heritage of mankind or under the sort of freedom of the high seas or something else. And also some concerns, particularly by developing countries, about lack of implementation of the technology transfer provisions of the convention. So that was kind of one set of concerns that particularly a number of developing countries had. And there was also another set of concerns that many countries had about the implementation of the environmental impact assessment provisions of the convention in relation to the high seas. And also about the lack of a process to establish legally binding marine protected areas under the convention in the high seas. So these were issues that were kind of contemporary oceans and law of the sea issues that were being discussed for around a decade in the ad hoc working group. And eventually there was really agreement to try and join those together into a package of kind of 4 key issues to try and resolve and essentially to negotiate a third implementing agreement to the convention. And that's what the preparatory commission that met for 4 sessions across 2016 and 2017 was tasked with trying to do. And then that led to the Intergovernmental Conference, which is having its 5th session right now in New York, and had its first earlier sessions over 2018, 2019, and then had to pause due to COVID. So in terms of the likely role that the General Assembly will continue to play in the future, I think it is going to continue to play a role in implementing the convention in the absence of any other body that has universal membership and the ability to play that kind of role. I suppose if there were universal membership of the convention, then potentially the states parties meeting could play a role like that, but there hasn't been a lot of appetite for that, because if you were going to do that, that would exclude a number of key players. And it's also possible that the Conference of Parties envisaged under the draft agreement on biological diversity beyond national jurisdiction may be able to play a key role in some of these areas as well, but obviously its scope doesn't include the whole of the convention. So I would say that for the foreseeable future, we can probably expect the UN General Assembly to continue to play a role.
Thanks so much, Alice, for those reflections. That's really valuable. And we're now going to turn to the pre-recorded Zoom presentation with Associate Professor Joanna Mossip. This was recorded about 2 weeks ago. Joanna is an Associate Professor at Victoria University of Wellington Faculty of Law, and she's also Associate Dean Research at the same institution. And Joanna is also a co-chair with Camille Goodman and myself for the event that we're planning for December 2022 to celebrate the 40th anniversary of the Law of the Sea Convention. Joanna will discuss with you her current role in New York. She's not giving us a real-time update, so please be mindful of that. And that discussion between myself and Joanna goes on for about 15 or 16 minutes. And at the end of that, we'll have an opportunity for some questions. So those of you who wish to ask some questions, feel free to begin to frame them or put them in the chat function. So Charlene, can I ask you to start the video presentation, please? So welcome, Joanna, and thank you for agreeing to be part of the webinar.
Thank you, Don. It's a pleasure to be here, and I'm sorry I couldn't join the seminar in person.
So, Joanna, in this conversation, we're going to be looking at the general theme of the webinar, and that is the Law of the Sea institutions. And some of the other participants in the webinar have been looking at the foundational institutions that were envisaged when the convention was concluded. But you've got a lot more contemporary perspectives and experience in some of the more recent institutions and institutional developments that have been occurring, and that's what I wanted to focus on in terms of this discussion. So first of all, can you just take us through the processes associated with the IGC and how they are related to the United Nations General Assembly, and then from a treaty law perspective, perhaps offer some reflections on the outcomes of the IGC and how that will impact on the LOSC.
Thank you, Don. I should first begin my comments by saying that, of course, I am an observer on the delegation and I don't represent New Zealand in any official capacity. So what I'm about to say is very much my own perspective. In terms of how the IGC has come about, the Intergovernmental Conference is actually the culmination of about 16 years of work, all under the auspices of the General Assembly. So it started in 2006 with a series of ad hoc informal working group meetings, which raised the general issue and was starting to talk about whether or not a treaty was required. In June 2015, the General Assembly authorised the creation of a preparatory committee to make recommendations to the General Assembly on the elements of a draft treaty. And then in December 2017, the General Assembly Resolution 72-249 established the IGC, gave authority for 4 meetings, and it also set out what the negotiations were to contain. And essentially it was to address 4 elements or topics. 1 was marine genetic resources, including the sharing of benefits. 2 was area-based management tools, including marine protected areas. 3 was environmental impact assessment, and 4 was the capacity building and the transfer of marine technology. Another really important aspect of the General Assembly resolution was that states were instructed not to undermine existing global, regional and sectoral bodies. So that was a really important aspect, and it continues to be a very important aspect. So we've had, in terms of the IGC, we've had 1 in 2018 and 2 in 2019. Then, of course, we had a hiatus due to COVID, and the 4th meeting of the IGC was in March this year. At the time of the seminar, the 5th meeting will be underway, and as part of that process, there's been 3 draft texts that have been produced by the President, and we'll be discussing the 3rd at IGC 5. In terms of the relationship to UNCLOS, the resolution described this as an instrument under the Law of the Sea Convention. It doesn't directly say anything about it being an implementing agreement, but most commentators and participants are referring to this as an implementing agreement under UNCLOS. And this is further reinforced by the fact that the treaty, the draft text, has exactly the same language as that in the fish stocks agreement, that the agreement must be interpreted and applied in a manner consistent with the convention. So we expect that it will form part of the 3 implementing agreements under UNCLOS.
So thanks for that background, Joanna, which is really helpful, and we'll obviously be able to look closely at the developments coming out of New York during the webinar. You've alluded to the impact of COVID on the negotiations, and there was a whole lot of momentum built up in 2019 in particular, and a lot of expectations with respect to the negotiations moving forward in 2020. And of course, they've been slowed, as we know. What is your assessment as to the progress that's been made during this COVID period since early 2020 and the next steps that you anticipate might be coming out of the current meeting in New York?
Sure. Well, of course, there was been a very long gap caused by COVID, and a lot of people were very worried about that. The lack of progress was seen as unfortunate, particularly given, the ocean continues to be impacted by human activities. But in actual fact, I think it actually turned out to be somewhat beneficial. The reason for this is that the delay for the IGC4 allowed states to really think quite deeply about their position. And there was a lot of activity intersessionally. So, for example, the president of the conference, Rena Lee, created a number of informal discussions for states to discuss online the issues that are raised by the negotiations. And a lot of NGOs, academics held workshops and seminars in that in that period. So actually, when states resumed the negotiations in March this year, there was a palpable sense of positivity about the process itself. States seemed to turn up mostly with a will to forward the negotiations. There was a lot of reference to each other's positions in a way that hadn't been seen before. I think it had been quite static in the past, but this felt like more like a conversation and actual negotiation. So the outcome of that was a sense of optimism, I think. And the rhetoric at an official level was that the aim would be that we finish the treaty in IGC 5. My view is that I think that may be overly optimistic. There are several extremely important issues that states are still divided over, and it is still hard to see where the compromises exist to resolve those problems. Probably the most pressing issue is the issue of marine genetic resources. So when I first attended the ad hoc working group in 2006, the divide between opinions on whether the MGRs should be dealt with under freedom of the high seas or common heritage of mankind was very, very severe. And actually that's still the case. It's probably softened. States have come a little bit more towards the middle. But the G77 has been very insistent that the common heritage of mankind should be the basis on which MGRs are regulated, and it should be in the text. Whereas industrialised countries in general have been reluctant to accept that or any idea that monetary benefits should be shared. And there are other problems with MGRs. And another issue that's still unresolved is the respective capability of the new Conference of the Parties, or COP, as compared to other global sectoral and regional organisations. At the risk of painting with a broad brush, the developing countries have generally preferred the position that the COP will have quite a lot of institutional authority, even where there are existing organisations. So, for example, in creating an MPA, the COP should be able to have a role in that, even if there's an existing organisation with the authority to do it. Whereas other states think that that would undermine those other organisations, which, of course, we're not allowed to do according to the General Assembly. So, given those divides, I think there's kind of two possible outcomes for IGC 5, and given this is my prediction at the moment, I may very well be overtaken by events. The first one is that if there's a real effort to get a treaty, then I think what's going to happen is it's only going to be achieved by, first of all, tossing out a lot of the text that's there at the moment, and second, leaving a whole lot of very important issues for the COP to deal with in a later stage. And I believe that would probably mean that any efforts to get an ambitious treaty would probably be failing because of the need to compromise at the last minute. Another option for how we proceed is that we try to push those areas where we really need to get some compromise and get a basic understanding of where the compromises would be, and leave it to another meeting of the IGC to conclude the treaty and the details of that. So, you know, this is going to be a really important moment, I think.
So, Joanna, you've painted a really helpful picture in terms of the issues behind the negotiations and the way in which the negotiations have really been, in your words, I guess, partly reinvigorated by the break. But you've also painted some realistic pictures in terms of the issues that confront the successful conclusions of the negotiations. As you know, this webinar is really looking at LOSC institutions, and you've alluded to some of those issues in terms of this IGC. What do you think would be the significant impact for the LOSC institutions as a result of the outcome of these negotiations?
Well, I think the institutional aspect is actually a place where the treaty will really break new ground for the law of the sea in general. So there will be at least 4 institutions or structures created by the treaty. These are the COP, the Secretariat, a scientific and technical body, and a clearinghouse mechanism. And there are other proposed institutions or subcommittees, including a compliance committee or one focusing on access and benefit sharing. I think that the Law of the Sea and the Law of the Sea Convention in particular has really suffered by the lack of an institution with overarching perspective on the law of the sea. And I think the BB&J negotiators have learned that lesson and have generally accepted the need for ongoing institutional mechanisms to oversee the implementation of the treaty. But I think one really important question remains in terms of what will the COP be able to address once the treaty is in force. So one option is it only can take up issues connected with the 4 elements of the treaty. Another option is that it might be able to take more of a CBD approach and sort of sees itself with matters that generally relate to marine biodiversity beyond national jurisdiction. So, for example, if we had new activities arising that didn't fall within an obvious institutional home, could the COP step in to regulate that sort of activity? And I'd like to see this, I think, because it partially resolves the general lack of institutional mechanisms for Law of the Sea from an oversight perspective.
So there are some quite significant developments that you've identified there, Joanna, and as you rightly say, the LOSC did not have an overarching institutional framework as we see in other major multilateral agreements. But it did, of course, establish some significant institutions, and they have been the main focus of this webinar. So asking you to sort of step back now as an academic who's very knowledgeable about the law of the sea and has looked at multiple aspects of the institutional frameworks and mechanisms, how do you reflect on the performance of those institutions within the convention, and what challenges do you think might arise from the interaction of those foundational institutions with ones that might emerge out of this current negotiating process?
Well, thank you, Don. So my view of the existing Law of the Sea institutions is that we've essentially got a decentralised system with different bodies having control over different sectoral activities, shipping, mining, fishing, and so forth. And I think one of the problems is that decentralisation often means that we're unable to properly coordinate activities or take a big picture view of the issues facing the ocean. And obviously this is a system we've inherited, even predates the Law of the Sea Convention in some cases. And for a long time, I think it's been somewhat adequate at reducing or mitigating human impacts on the oceans. But I think it's now becoming increasingly evident that human activities are having a significant negative impact on the ocean. And the existing institutions haven't actually been able to address this, in the way that it needed to. So I think the BB&J Treaty will hopefully make some progress, for example, with coordinating the establishment of marine protected areas and in perhaps creating fora in which those existing institutions can coordinate and cooperate more than they have done in the past. But I do think that the instruction that the BB&J Treaty must not undermine existing treaties and bodies essentially beds in the decentralisation that hasn't necessarily served us well in the past. In relation to that, I think that's why I think the mandate of the COP will be very important, because I think it potentially could play quite an important role there in trying to reduce the disjunction between the different organisations. But I also think we may see some competition between the COP and other institutions who are very much wanting to avoid any interference from the Conference of the Parties. And we've seen that in the negotiations and previous meetings where the institutions like the International Seabed Authority and the IMO have turned up to sort of say, we've got this, we're dealing with environmental problems. So Yeah, but I think for me, I think the recognised value of the treaty may be its ability to influence other organisations indirectly through the states that are party to both the BBNJ and those other agreements. So states parties to the BBNJ might be able to try and raise the environmental performance of other organisations by urging for the incorporation of standards and processes that are consistent with the BBNJ in a similar way to the way the fish stocks agreement led to a lifting of standards in regional fisheries management organisations. But whatever the outcome, the conclusion of the BBNJ treaty is, as I said, an important moment for the Law of the Sea Convention and its institutions.
Indeed, it will be, Joanna. So look, Joanna, thanks so much for joining us in advance of you travelling to New York. We wish you have a successful engagement in those processes, and we look forward to reading about the outcomes of the IGC and no doubt in due time hearing some more of your reflections on that. So thank you again, Joanna, for joining us today.
Thank you, Don.
Phil, I'm just going to go to you because there was a question that was asked of you in the chat a little earlier of states in their submissions and why. So have you had a chance to reflect upon that a bit?
Yeah, thanks, thanks, Don. Yes, there was a chat question from oh, just lost it now. Where is it? There we are. From Sophie York, and I don't know whether she's still, oh, she is still online by the look of it, but it's not totally clear to me what she's getting at, but she asked the question, quite a general question, what were examples of what states sought in their submissions and why? Well, of course, it's difficult to get into the minds of why states have not made submissions for extended continental shelf, but of course, by delineating the outer limit of a continental shelf beyond 200 miles, you're increasing the size of your 200-mile continental shelf regime considerably in some cases. And of course, that gives you sovereign rights, not sovereign territory, but gives you sovereign rights for the purposes of exploring and exploiting the natural resources of the seabed. And that includes mineral and other non-living resources, but of course also living resources of the sedentary species that live on the seafloor or within the seabed itself. So I guess most states have at the back of their mind, or even in many cases at the front of their mind, that there may be some economic benefit to the state in making the submission and eventually, hopefully from their point of view, proclaiming an outer limit for a continental shelf beyond 200 miles. But I'm not sure that's exactly what she's getting at, but with a question, but I don't know whether she's able to, whether you're able to allow us to enhance that at all.
Thank you. That was very helpful. Thank you.
Thanks, Sophie.
And Phil, there's another question there in the chat function to you from Lan Nguyen, looking at the role of the scientific and technical guidelines for the CLCS and some of the challenges arising from that in terms of the inevitable legal issues that have arisen.
That's right. Well, that's a very interesting question, of course, and it's one that sometimes, well, when you use the word interpretation of the convention, or particularly in terms of that provided by a scientific body, it does raise the hackles of some international lawyers. But I think over the years, people have realised that the CLCS has to be presumed to be competent to deal with issues concerning the application of Article 76 and make interpretations with respect to carrying out its work with regard to the implementation of that article. And And of course, we all know that there was no need for there was no legal requirement for anyone, for members of the commission to be there. They're all scientific. Their election to the CLCS was based on their scientific expertise, which was set out in the convention quite clearly. But I'll get into the bottom. He asked the question. People can probably read it, but he asked the question down towards the end of his chat statement that, can you perhaps provide some more insights into how the CLCS approaches the task of interpreting legal terms in practice? Well, it doesn't really interpret substantive legal terms in practice, but and of course it's worth noting the Commission doesn't explicitly provide a mechanism for the CLCS to obtain legal advice and input on substantive matters. There have been a number of procedural matters that the Commission, the CLCS, has sought the advice of legal counsel of the UN on a couple of occasions, and one of these related to the adjustment of submissions and amendment of submissions, if you like, during the time that the CLCS was actually considering the submission, and the CLCS did take on board the advice provided by the legal counsel on that particular matter. But there are some really interesting questions that, of a legal nature that potentially will impact on the workings of the CLCS, and one of them that is worth thinking about and is what will happen, what will the CLCS do if it receives a submission from a non-state party to the convention? I mean, lots of international lawyers have speculated about this, and I don't think it's necessarily a question that won't arise, even over the next couple of years. So it's a very interesting question. I don't know. I don't have an answer to it, but there are a number of potential things that could happen. But that's an important legal consideration, and I can't imagine the Commission on its own taking on a response to that. So perhaps the states, meeting of states parties, or some other, the legal counsel themselves may have opinions on this, but it's very difficult to envisage how what the result of such a submission would be at this time. And there's also other examples of things that have happened during my term on the CLCS, and where disputes have been raised by third-party states with who are not neighbouring or adjacent states, as referred to in the convention, on matters that are not outside Article 76. I mean, they might relate to Article 121, for instance, on the nature of the land territory itself. Well, obviously the Commission has no mandate to make interpretations on other parts of the convention beyond Article 76, and that has led to some real difficult situations for the CLCS on occasion, and even its own guideline, its own rules of procedure, in Annex 1 of its rules of procedure, which covers dispute situations, doesn't really cover that situation directly. And but usually the CLCS has found its way through it, and on one occasion at least, it actually set aside that part of the submission area in terms of its recommendation. It examined the area, but it didn't follow up with recommendations on that area, but it did on all the other areas. So it's usually found ways through this, but of course it's not the ideal situation to have incomplete areas that haven't been properly recommended on in a submission. It would be, I think there were other ways it could have been done in the past, by the Commission just going ahead and actually looking at submissions with respect to Article 76, regardless of any legal complications with regard to the nature of land territory, etc., knowing full well, of course, that it has no right to make such assessments, but also these matters that can be followed up by the states themselves using other procedures, like through arbitration and other matters where they interact with other states. So it doesn't require the Commission itself, the CLCS itself, to form any judgments or opinions about such matters. It just goes ahead and does its work. And then if there are people have an issue with it, they would take it up through other channels and other mechanisms provided in the Convention. So I don't know whether that answers the question, but there are some very interesting legal issues that will impact on the workings of the CLCS potentially over the next couple of years.
Now, Camille, I see that you've posted a question, so I'll hand actually the final few minutes over to you to ask the question of our panelists and to close out the event.
Thanks, Don, and thanks for all your sharing. Perhaps we might use this as a final observations type round. Given that we are an ANZSIL Australia and New Zealand seminar series, I wondered if you might each just want to give one or two comments on some particular themes or vibes or perspectives that have come through from Australia and New Zealand in your engagement in these institutions. And maybe I'll go in reverse order and go to you first, Alice.
Thanks, Camille. That's a great question. I was just thinking about that, and I think there are definitely some things where you can see Australian and New Zealand perspectives being distinct in relation to the law of the sea as we've been discussing. And I was thinking, and Phil and Mark will probably have more to say on this, but I remember at the time I was working on New Zealand's continental shelf submission, learning that the nature of the continental shelves in the South Pacific is quite different than those up in the Atlantic. And so actually needing to kind of educate the rest of the world about even the geography, let alone the relevant law. So they might have more to say on that point. But I was also thinking about how that South Pacific context and so many of our neighbours being small island and developing states in the Pacific has definitely influenced, I think, the way that both Australia and New Zealand have engaged with law of the sea issues, thinking about the relevance of islands, thinking about the impact of drift net fishing, thinking about, I suppose, probably sometimes there can be a bit of a divide in these things between industrialized nations and developing nations. And I think there've been times when probably both Australia and New Zealand have been able to help bridge that a bit just because of having that closer relationship with small island developing states in the Pacific. Thanks.
Thanks, Alice. Great set of insights. Always different when you start to think about not just the law, but the law in context. And our Pacific context is so interesting and so rich. Mark, what about you?
Thanks, Camille. I think Alice's comments actually were quite useful because for some of us, Phil and myself as well, we've had a broader engagement in the application of the convention. And I think that both Australia and New Zealand are seen as being constructive in trying to develop the practical application of UNCLOS and not being particularly partisan, pushing, well, for the most part, not being particularly partisan, pushing a self-interested perspective. Certainly in the ISA, because neither are seen as being promoting seabed mining, but are seen as being engaged in a way that is trying to produce an effective administration of the ISA. There is a lot of respect there. And can I say that there are a few things that got me involved in this area. And one was when the first Secretary General of the ISA visited Australia to try and increase Australia's participation in the ISA and gain support in support for the Secretariat of the ISA and bringing on board Australia's expertise as a resource administrator. So certainly Australia is being seen as being, and New Zealand as well, as being seen as constructively engaged in a less partisan way than other states. And so I think that is well respected and gives us a lot of capacity to positively influence the development of the convention. Thank you.
Well, that's a really nice reflection, Mark. Thank you. And Phil, you're going to get to have the last word as we just wrap up. You got the first word and now the last word.
Thanks very much, Camille. Yeah, it is a very interesting question. I think, as Mark has said and Alice have both said, is that I think Australia and New Zealand have been look on very positively with regard to UNCLOS in general, but also specifically from my point of view with the delineation of the extended continental shelf. And both countries have been very supportive of other states, particularly in the Pacific region, in helping them and supporting them preparing submissions and understanding the significance of doing that work. There's an interesting aside to this. Of course, we did have our moments as well, I remember, and Alice may well remember this, but we had a submission in place and already being examined when we were still negotiating or doing maritime delimitation with New Zealand. And I remember at the time we had some adjustments to make as a result of that delimitation to the area that we were trying to support in front of the subcommission at the time, and everything went. It was a bit of an unusual situation for the subcommission because I don't think they really expected that could have happened or it would happen, because most of the time delimitations are either finalised before submission or following submission and receipt of recommendations from the Commission. But in this case, it actually happened during the submission consideration process, but it all went fairly smoothly, I think. And adjustments were made, and of course there were a number of interactions with the subcommission on that matter at the time, but it all sorted itself out. And I know Australia and New Zealand, throughout their preparations of their submissions and also during the defence of their submissions in front of the Commission, were talking continually about the implications of various aspects of the interpretation of Article 76 and how the Commission was operating, and that was then passed on to, as I said, to other states in the region and also throughout the world. I mean, Australia and New Zealand have supported countries throughout the world and provided quite interesting advice and input into their submissions and to their other parts of the convention as well.
Well, thanks very much, Phil. As always, we feel like we've dipped our toe into something that we could talk about for a long time, and a continuing theme about the relationship between Australia and New Zealand in this sphere, and the idea that there are a lot of good war stories we could hear if we ever get to sit down and have a drink. So with that, I'd like to thank all our speakers very much, and our chair, Don Rothwell. We've heard a range of really rich and detailed observations and insights on a range of topics from a range of perspectives, not all of them lawyers, which is also a treat. It's been great to hear from such experienced practitioners who've been involved in these institutions and issues in such a hands-on way. Now, our fifth and final webinar in this series will be in October, and we'll be focusing on dispute settlement under the Law of the Sea Convention. So we'll be following up with information about that in due course, and I hope you can join us for that discussion, which I'm already looking forward to. If you've missed any of the previous webinars, or if they were so good you just want to watch them again or recommend them to your colleagues, the videos are available on the series website, as the video of this one will be too. So with that, can I thank you all once again for joining us, and again thank our speakers and invite you to join me in thanking them. I hope you enjoyed the discussion as much as I did. So good night, and have a very good evening, and we hope to see you at our next webinar.